COVID-19 task force. I'd like to remind everyone that this is an open meeting and subject to the North Carolina open meetings laws, and that this is also being live streamed to allow access by the public and the media to our meeting. I'll ask everyone at the outset to please keep your microphones muted unless you're speaking. I'll also ask that as you do participate in the meeting, that you introduce yourself each time that you begin speaking, so that those who are listening will be able to tell who is speaking. So with those opening comments, I'll ask for Emily to call the roll for attendance, please.
Judge Bridges.
Present.
Judge Corpening, you're here. Judge Sermon.
Here.
Judge Vincent.
Present.
District Attorney West. Mr. West.
Yes, I'm here.
District Attorney Evans.
Here.
Clerk Johnson.
Here.
Clerk Gary.
Here.
Kinsley Craig. Here. Kelly Myers.
Here.
Jason Cheek.
Present.
Jennifer Harjo.
Present.
Mr. McCabe, have you joined us yet?
I'm present.
Great. Mr. Harrison.
Here.
Mr. Weed.
Present.
And Mr. Keister.
Present.
That is everyone, Judge Bridges and Judge Corpening.
Thank you, Emily, for that. This is Jay Corpening. The first item of business is to approve the minutes from our last meeting. Those minutes have been sent to each of you by Danielle Carmen. Any additions or corrections to the minutes that have been submitted to us? Hearing none, is someone willing to make a motion to approve the minutes?
I move that the minutes be approved as circulated. This is Wade Harrison.
This is Patrick Weed.
Just to make sure that Emily got that, this is Jay Corpening. Motion made to approve the minutes, Wade Harrison, and seconded by Patrick Weed. Any discussion on the motion? Right, then we'll do a roll call vote on approval of the minutes. Vote yes or aye to approve, vote no or nay to disapprove. Emily?
Judge Bridges.
I vote yes.
Judge Corpening.
I vote yes.
Judge Sermon. Judge Sermon.
That is yes.
Okay. Judge Vincent.
Yes.
District Attorney West.
Yes.
District Attorney Evans.
Yes.
Clerk Johnson.
Yes.
Clerk Gary.
Yes.
Kinsley Craig. Yes. Kelly Myers.
Yes.
Mr. Cheek.
Yes.
Jennifer Harjo.
Yes.
Mr. McCabe.
Yes.
Mr. Harrison.
Yes.
Mr. Weed.
Yes.
Mr. Keister.
Yes.
That is everyone.
Thank you, Emily. The minutes are approved. We'll move now to the reports from our committees and working towards finalizing our immediate recommendations for our next report to the Chief Justice. And at the outset, I want to say thank you to all the folks who have come together in these working groups to try to craft recommendations that will be helpful and useful for all of us as we move forward in this. I know you've been working hard, and my special thanks to the folks, and on behalf of Judge Bridges, our thanks to the folks who agreed to chair these committees and take on these tasks. So with that, first I'll recognize Kelly Myers, Chair of the Best Safety Practices Working Group for an update. Kelly?
Thank you, Judge Corpening. I have not, to my knowledge at least, received any other suggestions or feedback from the task force regarding the draft best safety practices that we submitted last week. So I don't have anything else really to add to those. Our group has not met since the last task force meeting because my attention was drawn in other directions over the weekend and Monday trying to get our court facilities ready to open on Tuesday after resulting damage. So I apologize, but I have not convened them again. I am working now, Anna Starnes with the Chief Justice, and I have an intern, a part-time intern now from North Carolina DHHS.
Efforts to maintain a safe.
I'm sorry? So Anna and I have an intern from North Carolina DHHS now, and an intern from UNC School of Law, who are going to be working together with us next week to try to draft a best safety practices for jury trials and jurors that I then hope to present to our best safety practices working group and work through that next week for presentation to the task force.
This is Jay Corpening. Thank you, Kelly, for that update. Any questions for Kelly or comments about the report that her committee submitted last week? All right, hearing none, thank you, Kelly, and your entire committee for your work. It's really important work. Thank you. Moving to Technology and Innovation Working Group, I'll recognize Senior Resident Chuck Henry.
Okay, thank you very much. Can you all hear me?
Yes.
Okay, great. Thank you, Judge Corpening. We together and finalized an intermediate list of recommendations, which I believe was handed out, maybe not in final form, but almost final form to you before this meeting. The working group met with the idea of having this completed by your meeting today. And the final vote was conducted via email this morning. But the changes were minor, and with regards to the recommendations, there are about 15 of them. I don't know if anyone has a question about any one in particular, but I will entertain, as well as the other members of the working group that are on the task force, with regards to any such questions. Some of the recommendations address district court matters, so I'll defer to them, and some are appropriate or relevant to clerk of court dispositions and superior court and district court. But I don't know if you've had an opportunity to look at it. If there are any questions, I'll be glad to try to answer them. Or if anyone wants a clarification, we'll try to give you that now. I don't know if you want to go to jury trials now, but I think that's on your docket or on your proposed agenda for later on. So Judge Bridges, I'll defer to you as to how you want to handle this. Or Judge Corpening, I'm sorry.
So I'll defer to Judge Bridges. It may make more sense to talk about that section of your report later in the agenda with the item that Judge Bridges will preside over. Judge Bridges, does that meet with your approval?
Yes, sir. I agree with that.
Okay, Judge Corpening, one more thing. We're not through with this. We divided up, as you know, into 3 different categories. One is immediate, one was intermediate, second was intermediate, and the third is long range. We're going to meet again to do the long-range recommendations. Is our goal to have that done shortly, but we don't have that meeting scheduled just yet, but I would anticipate it being at the first part of next week and having something in your possession by the end of next week. So that gives you a schedule, an idea of what our plan is for work as we continue. And I'll defer back to you as to any questions or requests for clarification.
This is Jay Corpening. Thank you, Judge Henry, and thank you for the work that your group is doing. Questions for Judge Henry, comments about the Technology Innovation Working Group intermediate recommendations. They had already submitted their immediate recommendations, and we included that in their report last week. So any questions or comments for Judge Henry at this time? All right, hearing none, let's move to the Virus Fatigue Working Group. Jim Drennan is with us. Jim, thank you for the work that you're doing and the work of your committee. Glad to hear from you now.
Thank you, Judge. This is, for the record, Jim Drennan. Our committee has a report, actually. I think you may recall, if you've been around at the earlier meetings, that we're working on about 3 different products to get out to the people in the court system as soon as possible. One is a short video to build awareness. A second is a longer document that details signs of stress and strategies for dealing with stress, as well as identifying some more intensive resources that are available to people who need extra help. A part of that will be a single page bulleted point compilation of what's in the longer document. So we envision these serving different purposes. Maybe the one pager being taped to your desk, or something that you put on the inside of a notebook or something, and the longer document being available for people to review and look at the specifics. And then finally, there's a colorful poster entitled Help Now, which has some things you can do when you're just feeling a little extra stress in the moment. It's very simple strategies, and I'm looking at one now. Drink a glass of water, count backwards from 20, go for a walk, listen to the sounds around you, notice your surroundings, touch the furniture. Those are very simple strategies. This comes from a trauma institute that's a national organization. Again, we think that might be nice to put on a bulletin board in a break room or other kind of places where people can just center themselves briefly and quickly. The documents are very, very close to being ready. They have, we've been fortunate. I got to give a shout out to Lori Cole, who's hopefully on this call. She works at the Administrative Office of the Courts. She's done tremendous work in shepherding these work products into a final, very attractive form. I gave her a document, and what I got was this very nice, visually appealing presentation. We'll get it to you as soon as it's final, which could be this afternoon. I don't know. I mean, the folks at the AOC Communications Office have been working hard and effectively, and they're very professional, and it's been really nice to just watch from a distance and see the good work they do. So watch your emails for those documents that you can take a look at. That we'll work with the communication office at the AOC to figure out the best way to get this information out to the field as efficiently as possible. Before I go, though, the video, we have a draft of the video. It's 5 minutes long. It's to build awareness and just to show some faces of people in the courts and how they've been responding. And so I'd like for us just to take a look at that, just to give you a chance to see it. Before we do that, I should tell you it's not final. There probably will be some additional faces added I don't think we've heard from everybody we wanted to hear from yet, but it will be final very soon. But this gives you a flavor of what we're aiming for. So we're taking a leap of faith that we can actually show you this video. My fingers are crossed. So Emily, let's try it and see if it works. I can't hear, but I can see it.
What was going to happen to me.
Can anybody hear it?
I serve as the Chief District Court Judge for Hanover and Pender counties. I'm also serving as the co-chair of the COVID-19 task force. Everyone is experiencing trauma as part of this pandemic. Everyone's trauma is real and it's personal to them.
During this pandemic, I worry about our courts and our families and our community. When I get down on myself, I think about the fact that we really will be stronger and better on the other side of this pandemic.
Every time I go to work, I think about my family. I think about risks. What I come across, what I touch, washing hands. So it's always in the back of my mind now. I, like many of you, feel anxious when I go to work on the front lines of this pandemic. I wonder often if today's the day I become statistic and don't even know it until later on.
I feel anxious when I think of the families who don't have incomes coming in right now. My hope for the future is that we've learned what wasn't good for our souls and we cherish our time together.
It scares me when I think about not being able to go out in public, not worrying about other people's health. Seeing great positivity in the way that our community has come together. Everyone is pitching in and trying to help people that need it.
The thing that I've missed most during this pandemic is being able to go out across the state and meet and see you. I feel that we do our work best as an AOC when we have an appreciation and an understanding of how each people are working on us. I, like many of you, feel anxiety when I'm constantly bombarded with news reports, internet articles, emails, and text messages regarding the coronavirus. One of the ways my family and I fight this anxiety is through our evening walks. It allows us to decompress, and more importantly, unplug, while enjoying each other's company in the great outdoors.
Some of the hardest things about the coronavirus has been the abrupt stop to what we know as business as usual. It's hard to do what we do when we're concerned about speaking with others face to face and preferring that nobody come into our office. I feel anxious about returning to the courtroom. Most of the courtrooms that I work, my desk is catty cornered between the attorneys and the judge. And being a bit of a germaphobe, as the inmates walk in and the court staff, I'm going to be holding my breath. Hopefully,
This experience has really taught me to slow down and helps me to appreciate my blessings. Please remember, you are not in this alone.
it scares me when I think about the detrimental impact COVID-19 had in our community. On a positive note, I've witnessed an increased use of technology in our courts, as well as support among court personnel and the legal community in response to the pandemic.
The biggest challenge our office faces during COVID-19 is that we want to be together and achieve justice for our victims. But the stressful part of it is we want to do this in a safe environment for both our staff and the public. During this time, we just don't have to be patient and compassionate with one another. We wish everyone a safe and healthy return. We're changing things in the courthouse that we probably should have looked at a long time ago. You're not alone. We're all going to get through this. Just stay strong. Take care of yourselves. Take care of your family. God bless.
And I would encourage you to do the same, to lean on your coworkers and lean on your judicial partners. We're all in this together, and together we can make it through. We're going to come out even stronger than we've ever been before.
In this pandemic, it has brought us back to what's important, valuable time with our loved ones. We're not alone. We wish everyone a safe and healthy return.
My hope for the future is that this time where everything seems to be up in the air, that we all come out of it more grateful. We're appreciative of our family and our friends and our colleagues and all of the relationships that really keep us motivated forward on a daily basis.
I pray that you have the strength that you need to get you through this, and that you and your families continue to remain safe.
We wish everyone a safe and healthy return. I just want to say continued good health and well-being to all of you. I hope to see you soon.
You are not alone. There is help out there. Please don't be afraid to seek that help. I hope everyone has a safe and healthy return.
Never before have we experienced anything like this. It's more important than ever before that we stand together, look out for each other, and that we take care of each other. Take good care and stay safe.
We wish everyone a safe.
All right, thank you. This is Jay Corpening. Emily, thank you for sharing that with us. Sorry that the audio was a little challenging, but all this was pulled together within the last half hour. So thank you for sharing it. Jim, anything else from your committee?
No, I just know that when you see the video on YouTube or anywhere else, the sound will be much, much better. But that gives you a sense of what we're trying to do and the message that we're trying to communicate. And I appreciate all the people who took the time to record, and I need to thank the members of the committee. They've been great. And the video committee was actually Judge Corpening and Lori Cole and Mebin Boyd, who is a non-court person but worked with us. So yeah, thanks to all. We're going to continue to meet and see if there are other things we need to do. But this was our first challenge, was to get some of this information out now. And so the next piece is to be determined. But thanks to all. I'd be happy to answer any questions.
This is Jay Corpening. Any questions or comments for Jim and his committee?
This is Danielle. I just wanted to note, Jim, that Wade Harrison had sent a chat asking about how this will be distributed. I don't think we have a final plan, but I didn't know if you wanted to speak to that.
I'd say, Danielle, you answered the question. I don't know what the best means available to the AOC Communication Office, what the best method to do that is. I hope to talk with Lori and Sharon Gladwell and others as soon as we get these products finished. But we do need to think about whether we do it more broadly than that. And so if you have thoughts about that, please share them with me or with Danielle or the other co-chairs, and we'll talk about ways to distribute it more widely. Some of the information in the document is internal to the people who work in the court system. That is, there's some links to extra help that are only available for people who work in the court system because of a contract that courts have with a third party. But that's the only thing that is the least bit proprietary. So if you think this should be distributed outside the normal means, let me know. We'll talk about that, because we're meeting soon. The first challenge is to get it out to people in the court system. But thank you for the question. We have the same question, actually.
This is Jay Corpening. Other questions or comments for Jim and his committee? All right, hearing none, then we'll move on to item 4, resumption of jury trials. Judge Bridges. Judge Bridges, you're still muted.
Sorry. This is Don Bridges, and before moving on to discuss jury trials, I wanted to add my thanks to Jim Drennan and members of his committee or his work group for that excellent piece of work. Y'all have really done a great job in pulling a lot of good information together in a very short time. And many thanks for a job well done.
Thanks.
But now I do want to resume our discussions on the resumption of jury trials. And I hope that all of you received an email that I circulated late yesterday alluding to the report from the Technology and Innovations Committee and attaching to that email a portion of the report from that work group. In reviewing where we are and how we got here, as all of you will recall, we took the vote last week, and that vote concerning a recommendation to the Chief Justice concerning the resumption of jury trials wound up being a very close vote. So even though technically the resolution passed, as I indicated in my email, I have very significant reservations about making a recommendation to the Chief Justice when it seems that we are so far away from being able to speak either in one voice or even a substantially united voice as to exactly what our recommendation would be. I was struck by the number of concerns expressed and the fact that these are not frivolous concerns. They're not ungrounded concerns. They're very well reasoned, very well grounded, justifiable concerns. And I think those concerns need to be considered by all of us. Now, in that context, I also want to speak briefly, very briefly, in terms of goals and deadlines. As you all know, we have set a goal for ourselves of trying to complete this first interim report and get it in a form that can be submitted to the Chief Justice on or before June 15th. Now that is a goal. That's not a hard deadline. On the other hand, we do have a hard deadline in the sense that the Chief Justice has given us until June 30th to submit some sort of plan for the resumption of jury trials. Given that we're talking about two different dates, two different aspects of what we're doing, in a sense, that begs the question, is it practical, feasible, is it realistic still to include in our first interim report that we're going to submit on or before June 15th a plan for the resumption of jury trials? Is this something that we can yet put together within the current time frame? Obviously, today is June 4th, so we're talking about 11 days from now. Is this something that realistically we can put together within the next 11 days, either through some modification of what we talked about last week, some totally new proposal, or through some other manner? Does anyone wish to weigh in on that point? Do you think that's realistic to go forward and try and achieve that objective by June 15th?
Judge Bridges, Kelly Myers, and just on behalf of the Best Safety Practices Working Group, I don't think it's realistic that we can have a quality product by June 15th to be included in this initial report. And, you know, from the beginning of this, we approached our task as immediate, what can we do now and how can we do that safely, recommendations, with an eye that the next sort of phase, for lack thereof, would be resumption of jury trials and doing that safely. And so I would just ask that we have and utilize until June 30th.
And thank you, Kelly. And in that regard, I will communicate both for Kelly's benefit as well as for the benefit of all other task force members. One of the principles that is implicit in the current draft of our plan for the resumption of jury trials is that any jury trial will be conducted in compliance with all best safety practices that ultimately come from this task force as submitted to us by that work group, the best safety practices work group. Now, in that regard, that work group has already provided us with recommended best safety practices for in-person hearings, but as I understand it, and Kelly, please correct me if I'm wrong, the best safety practices work group also plans to draft specifically a set of best safety practices that would apply in particular to the conduct of jury trials. Is that correct, Kelly?
Yes, sir, that's correct. And using our interns.
Okay. So that being the case, we still have some time yet to receive that information. And Kelly, I take it that you anticipate you would have that second set of practices that relate specifically to jury trials completed sufficiently in advance of that June 30th deadline so that we could incorporate those in a plan if we submitted that separately to the Chief Justice and not as part of this first interim report.
Absolutely.
All right. Is there other discussion on that point as to the advisability or inadvisability of trying to put together any form of plan for jury trials to be included in this first report?
Don, this is Waylon Sermons. I agree with Kelly. I think we need to work on it to refine it more.
All right.
Judge, this is Billy West. The only concern I would have, as you know, we were discussing the the potential for when the start date may be. Obviously there was some difference of opinion over that, but the longer we're not able to make a recommendation, the tougher position maybe that puts the Chief Justice in, or even the jurisdictions across the state. And that would be my only concern. Otherwise, I agree with being prudent and taking our time and so forth. That would be my only concern. Of course, I realize we're only talking about 15 days, but I would just kind of put that out to the group as a concern about waiting till June 30th.
All right. Well, let me, this is Don Bridges again. Let's take a step back here for a second, if we could. Judge Henry previously alluded to the fact that his work group met earlier this week. And in fact, I think you all probably received a couple of copies of some of their work product. One attached to my email that was circulated to you last evening was a copy of the last 2 pages of the report from their work earlier this week, which was only the portion of their work that related to jury trials. Judge Henry, would you or some other member of your work group be willing to give us perhaps a brief summary of what you all arrived at with respect to any of your recommendations concerning jury trials?
This is Chuck Henry. Can you hear me?
Yes, sir.
Okay. My group talked about this and discussed some issues, and Mr. Harrison brought up some, I thought, very valid points in regards to jury trials, and we discussed it. It was not our intent to be adversarial to some of the other work that has been done, but I just think there's some issues that I have that one is, if you look at the statistics for the state of North Carolina, I'll have to point out to you the graphs and the number of cases and deaths and what have you. That's concerning. We don't, even today, we don't know what the effect of some of these mass gatherings will have on those statistics. Hopefully it won't affect it too badly, but those issues are still being raised, and we probably won't know for a couple of weeks. What directed my attention to it was from the best safety practices document of May 28th, in which on page 4 they talk about currently public health officials are not aware of courthouse specific guidance and suggest looking toward recommendation for similar settings with regards to duration and types of exposure you expect to occur in the facility. And then the other thing that I thought was compelling was the general guidance of 6 feet for social distancing is for casual interactions between individuals for less than 10 minutes, and an hour is considered a prolonged period of time. It talks about airflow within the facility, use of masks, things that we probably have all thought about. The question I raised is, and I think only public health professionals can tell us, when you talk about lengthy trials of 2 to 3 weeks, what are the risks that we have to consider when someone is in that room? I'm talking about the jurors mostly, for 6 hours a day, 5 days a week. And what are the effects of that environment on their risk? Now, personally, I'm planning on maybe jury trials the week of the August 3rd. We need to, whatever plan we devise, we need to test drive it in the sense of maybe short trials, 1 or 2 days. I don't think inventory is a problem with any district attorney's office with regards to pending jury cases. But I need for public health officials way above our pay grade, maybe at the state level or at the request of the Chief Justice, to consider that issue, assuming all the distance requirements are in place, the masking is in place, the hygiene is in place. Assume all that is as recommended. What does this lengthy period of time being in a facility for hours during the day? And I don't think they can give us a definite answer, but at least they'll give us some guidance. And whatever they tell us, I think we need to convey to the jury panel that this is the best opinion of the public health professionals. And I don't know the answer to that. And because I don't know the answer to that, I'm just having some difficulty. Of course, I personally fall into a high-risk group. But what does a lengthy exposure over a period of weeks, there may be no exposure. If everyone comes into that courtroom and is pristine and has no virus issues, everything will be great. But the question is, when you talk about asymptomatic spreaders, there's no guarantee. We have to make a decision based upon the best professional opinions in public health that are out there. And I know that I read the DA's recommendations, and I concur with most of it. The question is, we can't guarantee safety. We can only express to the people what we have done to reduce the risk as low as we can. But I think we need that input from the best public health safety minds there are in the state of North Carolina. And I assume that various wonderful universities we have in this state, as well as healthcare providers in this state, can give us that guidance. I don't feel confident to express an opinion, except we need a date to plan for, but we have to understand that there may be some considerations that we have not considered yet. Mr. Harrison, I'm going to turn it over to him to maybe elaborate on what I've said, or have him express some of the opinions that he has from studying this. I know our recommendation for beginning of lengthy jury trials is out into the month of November. But again, this is a recommendation from our group, and it was not meant to be adversarial to any other group, but we just had some issues that I think need to be considered before we step out and ask our citizens to make that kind of dedicated service to our state when they show up for a jury trial that may last 2 to 3 weeks in length, and the exposure that may be involved. Thank you. So, Mr. Judge Bridges, I'm not trying to take over your job, but I'll turn it over. I'd like for Mr. Harrison to speak.
Mr. Harrison, are you with us?
I'm with you. Is it okay if I address it?
Yes, sir.
I'm not a jury trial lawyer. I've tried 3 or 4 in my career, mostly alienation cases. But I do take seriously the work of the task force, and I think that that it's incumbent upon us as a group to provide as much guidance and information to the Chief Justice as possible. And the group itself is a very diverse group, and was deliberately chosen to be that way. And I'm speaking of the task force. I wasn't happy with the way the vote went last time, primarily because I thought at the end of it, what we have is a fairly articulate enunciation of a number of different points of view without any sort of cohesive underlying structure for it. So what the work group came up with was basically a 3-legged stool. The first leg, and the most important leg, is the science and the public health interest. And the reason that's so important, and the reason it's so really expressed in the report, is because the courthouse is a place where people come that don't want to come. They don't have a choice about it, and so there's a duty to make it as safe as we can make it. The second part is the idea of having voice given and some authority given to the people who are most responsible for making the courthouse safe. And so we we came up with this proposal that that the senior resident superior court judge and the elected clerk in every county needed to agree about the whether or not that particular county had the facilities and the procedures in place to assure the safety of all participants in the jury trial. And that was a fundamental sort of fork in the road. And that recommendation was based upon concerns that were raised by the clerk. And I think there, even since our meeting, there's been a fairly detailed survey of clerks in the state that should be brought to our attention about that. But that was a check and balance that we felt could help assure that any given courthouse would be a safe place for a jury trial to be conducted. And that as a practical matter, given the circumstances that we're all involuntarily suffering as a result of this pandemic, whether as a practical matter it can happen, given the manpower or person power available to address the task. And then the last leg was sort of from my perspective, kind of a fundamental fairness leg. Serious felonies and long civil trials really inherently put people at more risk. I think fundamentally the problem is we don't know to what extent this virus is spread in vapor and how infectious it can be in that regard. So the idea of people spending a long time together, even with masks, is a problem. But more of a problem is the idea that people who are facing serious felonies and predictably will have trials of more than a week, that these people shouldn't be the guinea pigs for a new jury system. And that's the reason for the recommendation that those trials be deferred until November 30th, 6 months after the release of the House stay-at-home order. So that's the basis for the proposed compromise, and it does allow some jury trials to go forward on August the 3rd, provided there's three legs under the stool. And in a lot of ways, it's very similar to what the district attorneys have proposed. I mean, they leave out the clerk having the authority that our proposal gives, and they leave out inviting the criminal defense bar to the table for deciding the priority of cases. And I guess our proposal at least gives that authority about prioritizing cases, gives that authority to the senior resident superior court judge, and I think that's a little different. But this proposal is no substitute for the science, but it is a way that the work group felt had sufficient checks and balances in it and paid enough attention to the people who have the responsibility for jury trials to make it worthy of consideration. That's about as much as I think I can say about it.
Mr. Chair, this is Robert Evans. I'd like to make a few comments, if I might.
Yes, sir, Mr. Evans.
I'd like to say, first of all, that to the extent that the committee feels as though we are not at a level sufficient from a scientific and health standpoint, I don't oppose that. I think that's a reasonable position to take. Ultimately, it seems to me that no trial in this state is going to take place until there's been an assessment that it can be done safely. So as much as we can gather on the front end to put into the recommendations we're going to forward, the better. On the other hand, I think that the concerns I have at some of the issues that have been brought up is that, as far as I can recall, the ultimate arbiter of whether or not a specific case is right for trial are our trial judges. And I think we need to be careful putting any kind of artificial barriers that prevent that process from continuing the way that it always has, in my opinion. To the extent that the chief has already asked the senior resident judges of all of our districts to set up COVID teams and to set up COVID coordinators, it seems to me that whatever information we gather is eventually going to be forwarded district and statewide to all of the constituents. And I would assume that all of the COVID teams are going to be fairly representative of all the courthouse constituencies. I wouldn't think that a judge would leave anybody out as he or she makes the assessment about whether or not his or her district is ready to go forward with jury trials. And the other thing that concerns me is that, as I mentioned earlier, we need to be careful. I thought initially we all sort of agreed that we did not want to make recommendations that imposed a one-size-fits-all kind of a proposal. And I think some of what we're saying is going to get us closer to that than I'm comfortable with. In my district, for example, whether we start jury trials August 3rd or later, I have 3 counties, and I'm not certain that all 3 of my counties are going to be ready, even if we set a hard August 3rd date to proceed to jury trials at the same time. I think it's going to be a district by district, county by county analysis, given the best information we can provide the decision makers. And so I'm comfortable gathering as much information about safety procedures and practices as I can, but I'm not comfortable with putting barriers in front of the persons that we have always put our confidence in as having the information sufficient to determine when a trial can go forward, when it can't, and what type of trial can go forward. And so those would be my observations.
Thank you, Mr. Evans. This is Don Bridges again. I have a question that I'd like to direct to Judge Henry and or Mr. Harrison. And one point that was unclear to me from your report, at least in the copy of the report that I have before me, paragraph 4 reads, no capital case or first-degree murder case will be calendared before November 30th, 2020. I understood that your work group may have had some discussion about whether or not that would be specifically directed in that manner or would be more expressed in terms of certain classes of offense. I know that Judge Henry had mentioned to me, for example, the consideration that there are other categories of cases, for example, a class B1 sex offense case might be as complicated and as prolonged as a non-capital first-degree murder case. What was the recommendation of the work group in that respect? Was it as it reads in this paragraph?
I can respond to that. You got an earlier version.
Okay.
What was ultimately recommended to the task force was that no Class A, B1, or B2 felony will be calendared for jury trial, and it's because of exactly what you said. The policy perspective for that recommendation is to put more serious and longer jury trials off until the new jury systems can be in place and tested in the various counties.
Judge Bridges.
Yes, ma'am.
This is Teresa Vincent. I would like to say, I think it's often overlooked that we do have jury trials in district courts. And I would be remiss, I think, if I didn't speak on behalf of the chief district court judges, that I think we would be need to be a part of that decision making. I really would not be comfortable not having a voice as to whether or not I feel like we're ready to resume jury trials and allow a resident superior court judge and clerk to make a decision for the district court level of court. In terms of if we're going to make a recommendation as it relates to that particular issue.
Yes, ma'am. Thank you for pointing that out. That is an important consideration. All right. With regard to this is Don Bridges again. With regard to the points just mentioned by Mr. Harrison, please note then that the version of the recommendation that was attached to the email that I circulated to task force members last evening was not the final version of the recommendation from that work group, because the version that I provided to you all made reference to no capital case or first-degree murder case being calendared before November 30th. And as I understand the final recommendation from that work group, that would read no Class A, Class B1, or Class 2 felony would be calendared before November 30th, 2020.
Judge Bridges, I did email that version out to folks, I think right after 11 this morning, the final version.
Okay, all right.
This is Emily. The version that you're seeing on your screen now is also the final version.
Now.
Judge Bridges, this is Marsha Johnson, Clerk of Court. I have a few issues that I would like to bring to light on behalf of the clerks. One being procedural matters. A lot happens before a case actually goes to the trial, and some of the logistics that we would have to deal with now in order to have something ready by August 3rd, your timing is getting to be a little bit strained, because if we were to set a case for on August 3rd, if it was to be set, we would have to send those juror summons out the week of June the 29th. And that is just a few weeks away. So also, before we could send out the summons, we would have to know the logistics of where are we going to put the people, where are they to report to, do we have room, are they going to be in groups, is it the orientation going to be in one group, or is it going to be in several? And those are decisions that are going to have to be made by the players in each county. And so August 3rd would really be pushing us to get anything done. Even September, October, you've got to think way ahead so that we can get all of the paperwork and the computer programs for the jury acclimated to the new changes, because everything has been done the same way for so long. And now these are a lot of changes that have got to be made in paper and with computers and with the actual courthouse, because not many courthouses actually have room to put 75 to 100 people and observe social distancing. And that is one of the things that, we're in the 4 stages of this. And right now we're in the emergency curtailment limited operations phase. As long as we're in that, we have to obey the social distancing rules. It seems to me it would be a whole lot better, and who knows when it's going to happen, if we could at least start jury trials when we get to the relaxed social distancing phase. And right now we have a very high level of transmission of the virus. And that is noticed in some of the counties in the clerk staffing. most of the clerks have brought their staff back due to all of the courts that we're dealing with beginning June 1, but they are at a reduced level of staffing because of the number of people that are either sick or have been exposed and they're out with in the quarantine. I believe Mecklenburg County, she said she was operating at 65%. So there's going to be a reduced level of staffing to have to adapt to the new changes with the jury that's going to come in. Where we did one orientation for all, it may be to do to 3 different groups, take a full day, so it's going to require more personnel. So those are just some issues that the clerks would like to make known, that we're not comfortable with that August 3rd date at all. And that's about it.
Yes, ma'am. Thank you, Ms. Johnson. And of course, I'm sure you all have noted that in our current draft of the plan that we've included up to this point in our report, there's extensive discussion of the importance of conversations between the senior resident and the clerk about coordinating that very sort of thing. We mentioned that the plan needs to be drafted well in advance of the first week of jury trials because of that lead time that's required for issuance and service of the jury summonses, that there needs to be consideration also about staggered reporting dates, staggered orientation sessions, depending upon the accommodation ability of the existing facility. Another point that I think is very important for us to build into our plan is to try and stress to the local officials the importance of doing walkthroughs and actually making physical observation of the spaces that are going to be used for these purposes. One of the realities that we are realizing here in my home district, both in preparation for the current week as well as our preparation for the resumption of jury trials, is that you learn by doing. And until you actually get in the process, or until you at least do a dress rehearsal, so to speak, where you're physically present in the space and walking through, taking measurements, and trying to visualize how these proceedings are going to take place, you really don't realize what a challenge it is until you actually go through that. And I think it's going to be very important for us to express that in the formulation of our plan, the importance for the drafters of the local plans actually to do that on the ground. To, I believe Chuck Henry may have been the one who first expressed this to me, and thought that the judge himself or herself should walk the path that the jurors walk from start to finish, from the minute they walk in the front door of the courthouse until they have returned a verdict and been released and walk out either the same door or another door at the end of their service, so that the judge can know every single situation to which those jurors potentially are going to be exposed during their jury service. And hopefully that will be one of the points that will come across in the plans that we express. We've also got to be mindful of the actual physical presence of every other participant in the trial, and in effect sit in their shoes or sit in their seats as well as we visualize the process.
Judge, this is Billy West. Would it be a good time to highlight just a couple of matters from the DA's plan? I don't want to jump the gun. The work group, it has a lot of good information. I'm certainly not going to read it or anything like that. Everybody can read it for themselves, but would it be a good time to kind of highlight a few of those while we're talking about this, or would you prefer to wait on that?
Mr. West, if you don't mind, let me direct one more question back to the clerk, and that is the message I'm hearing from the clerks at this time is that the clerks have serious concern about the possibility of August 3rd as a starting date for the resumption of jury trials. That, in a sense, leads to the question, given that concern, do the clerks have an idea as to what they consider would be an appropriate timetable for the resumption of jury trials?
We have not discussed a perfect date that we think would be best. I think it's more of the logistics with the courthouses. As long as it is the social distancing of the 6 feet and the long trials where you would be in close contact, as long as we have to observe that, that's more like what we feel is going to be hard on us. So it's the stage of the social distancing more than an actual date itself, because so many of us have problems with being able to accommodate that many people at one place. And even if you divide it up and do several, you've got, most of your courtrooms are used every day. And sometimes there's not extra ones to use to divide up jury orientation into groups. So as long as the social distancing, we're in that phase where it's that 6 feet, it's going to be difficult. You know, and what we were hoping is that maybe later in the fall, it would get better to where we could be released from some of that and move on to the next phase where it's relaxed somewhat.
Judge Bridges, this is Elisa Chingary, Mecklenburg County Clerk. Good afternoon. I wanted to follow up on just a few points Clerk Johnson brought to the fore. I really appreciated the 3-leg approach. I think that those are all very important considerations. Embedded in there is, as Clerk Johnson mentioned, the structural examination about what needs to be accommodated. We have done the walkthrough, and we have determined that we have deliberation rooms that will not accommodate social distancing. We have eliminated what courtrooms could be used and could not be used as a result of that. We have been given from our public health officials information about cloth seating and the inappropriateness of using it, the danger of using it, the risk of using it in this phase of contamination. So we are thinking through if we're not allowed to invite jurors to our jury assembly room, where will we put a large group of people? That's the structural issues are real and complex. I'd also like to add that we have talked to our public health officials about the lengthy exposure. That was a real concern for me in having in-person hearings both in the morning and the afternoon, a full day. The public health recommendation that I received is that I should either encourage the court to take breaks during morning sessions and afternoon sessions, and if that was not feasible, then I should rotate my staff so that they are not sitting for long periods of time in a intact area. And that's with the social distancing occupancy requirements in place. So for all of those reasons, I think we are strongly adamant in our concern that August is premature. The structural issues during this high phase of contamination, that the level, we're one of the states that it continuously is rising, is a huge concern for us. So thank you for letting me share that.
Yes, ma'am. All right. And we had a request previously for further input from the Conference of District Attorneys.
Thank you, Judge. This is Billy West, and I'd ask Robert Evans anything he has to add to this. I was going to hit some of the highlights of our plan in response to the working group's plan. We felt like that there could be issues making any arbitrary classification of types of cases. That what we prefer is really what some folks have been talking about, but is a more localized approach. We're not aware in any of the research we've done of a single state where the Chief Justice has determined when cases can be scheduled based on some type of classification of cases, as far as lower level felonies, what have you. We think there could be some constitutional challenges involved in that potentially. Another thing that is worrisome, while I understand all the health concerns and that sort of thing, but they're listed in our plan. Many states have either begun or are about to begin jury trials. With very few exceptions of places that are looking to extend, beyond the August 3rd. The August 3rd is certainly on the, latter end of what we've seen across the country. I think the Chief Justice, with her wise plan of a COVID-19 coordinator and team, has put something locally in place to see when it is safe, when it is feasible to try jury trials in certain jurisdictions. And as Mr. Evans pointed out so well, that really could vary from jurisdiction to jurisdiction. And I really doubt that there's many jurisdictions out there across the state that are looking to start a capital murder case on August 3rd. And the local team would be the best place to determine the space that's needed, the safety that's needed, and that sort of thing. And of course, the August 3rd would be an aspirational date, which may work for some and may not work for others. As far as whose approval or whatever you need for calendaring the cases, I mean, under the statute, the district attorney is given the responsibility of calendaring cases. But I do think that in some ways we're subverting the authority of the trial judge. A trial judge can continue any case where they think that is appropriate. So you could have a COVID-19 team that's met. You could have a safe location. You could have a DA who's calendared it subject to the statute, and the trial judge feel like that it's just not appropriate to try that case at that time. Maybe it's because it's too serious. One of the sides hadn't had time to prepare what the case may be. But just to be frank, and I think there's been some great ideas with this group, but I think we're micromanaging this issue a little bit. And that ultimately it is certainly the Chief Justice decision, and then it's really going to be decided on a local level. And I think to get a uniformity, one size fits all, let's say November 30th, because in all 100 counties, we know that it can be done then. I just think that that's going to be almost impossible to attain. So I throw a lot out there. I'd ask Mr. Evans, because I know he's been involved in coming up with this plan too, if he has anything to add to that.
I think you've covered everything that I've said before, Billy. I'll just add this. All of us the clerks, the judges, all of us who've had experience in the criminal justice system in particular, I think we need to be honest and admit that when people say sometime in the fall, that puts us dangerously close to the year being over for any kind of serious trial. So I think we need to be mindful of the fact that pretty much, at least in my experience, after about the first week of November, there are very few serious trials going on anywhere other than those that have already started. And so we in terms of the DAs, the defense lawyers, and all of us who are concerned with the speedy and fair administration of justice, we're dealing with a very short window here. And, I respect all of the positions that have been posed, but I do think it's important for us to come up with a date for the Chief Justice to put in her recommendations. And I don't think that date needs to be too far into the fall, because if it goes too far into the fall, it's really not going to do any good in terms of what productivity we can expect in the rest of this year. So other than that, I think Billy has adequately explained the position of the conference.
Thank you, gentlemen. One of the quarters from which we heard significant opposition to the motion that was before us last week came from the criminal defense bar. And on this task force, those members are represented by Mr. Weed and Ms. Harjo. Do you all have additional concerns you would like to express today?
This is Patrick Weed. I'm also, along with Mr. Harrison, a member of the Technology and Innovations Working Group. And I am very much in support of what the working group has submitted, and hearing some of the concerns, perhaps with regard to the issue on item number 4, which is back on the screen, from the recommendations from the working group about the countering of serious felony cases. Perhaps some language could be added to say no Class A, B1, or B2 felony will be calendared for jury trial before November 30th unless both the state and the defendant agree and consent. And that perhaps could address some of the concerns that that have been expressed with regard to speedy trial and other constitutional rights that the defendants have. I think from hearing a lot of, so I really don't have much to add for what Judge Henry and Mr. Harrison stated very well with regard to what our working group has done. From hearing some of the comments today, another thing that I would add is I think it seems like there are two separate issues here to me. One is the health and safety component of when jury trials should begin, not only for the potential jurors, but also for court personnel as well. And perhaps we need to hear the final recommendation from Ms. Myers and her best safety practices group before we make final decisions with regard to dates and time frame, because that seems to be a big part of it. And that also seems to be what I'm hearing from the representatives from the clerks as well. And then I think the second issue is the mechanism by which each county determines and decides when they are ready to proceed, whether that is on the date that is provided that trials may begin or on a later date, and the issues that go along with that. But I think that with regard to lengthy trials, to have jurors sitting through lengthy trials for potentially more than 1 week and several weeks in a capital case, for example, and knowing that everyone is not going to be living in a bubble, and even if everyone were tested and healthy on the first day of the trial, that doesn't mean that someone may not come in after being exposed during the evening hours or over a weekend. I think that's another reason why there are a lot of concerns about having lengthy trials right now. Thank you.
Judge Bridges, do you mind if I speak up for a few moments?
Please do.
Thank you. This is Jennifer Harjo, and on my news feed, it says that North Carolina recorded the highest number of new cases in one day. So we are still on the upswing on this, and that concerns me. To suggest that August 3rd is a viable day, I believe the clerks are accurate. It's not a viable date. It's just not. I appreciate what was put together by the technology group. I think that is a remarkable, I don't know if I would necessarily say compromise, because I think it was just a very thoughtful suggestion. And I quite frankly agree with what was put together by the technology group, the proposal, the final report. I think it was thoughtful. It gave a lot of, made a lot of sense. Yeah, I don't believe that there was some talk about it being arbitrarily taking judges' discretion. I mean, we're in a pandemic situation, a worldwide pandemic situation. I think to start out slow when we reintegrate these jury trials is the proper method and the proper way that we can provide as much assurance and for safety for not only the jurors, but also the lawyers and the participants. As a representative of the defense bar, obviously I'm going to be concerned about the lawyers that are going to have to interact closely with the clients. Hopefully these initial jury trials won't be with people that are incarcerated, but they might, because those cases need to go. And the people that are incarcerated have been at very high risk. Last night I had 3 conference calls with 3 different clients, and I saw them get on the phone one after another, one who had just been in quarantine. There was absolutely no cleaning of the phone or the room or the devices that were used, despite the fact that I had asked our sheriff to make sure that the phones were cleansed between clients, but it wasn't done. So there is still a high risk in the facilities where our clients are housed, and that puts us at a very high risk because we have to interact with these clients to make sure we understand their defenses and make sure we protect their rights. The comment that I sent to Judge Bridges and to Judge Corpening by email, I did not send it to the entire group, was that I know there was some concern about whether or not the defendants should consent. And the reason I don't think that's necessarily inappropriate is because defendants have constitutional rights that they can waive. If a client decides he wants to waive a constitutional right to be able to see a witness's face, I think that's the defendant's constitutional right. And whatever rights they want to waive, they can do so. It may not be the lawyer's suggestion that they do so, but maybe there are protections that can be made in a jury trial that one defendant might not want to waive and another defendant may want to do so. And I think we should allow those options for the defendants. And that was the reason I suggested that in certain cases, if we're going to have a jury trial at an earlier date, if a defendant wanted to waive a right to put off the trial, I guess, so to speak, put it off for further protections, they had a right to waive those protections and suggest, I'm going to agree to have a trial now earlier, even though perhaps they're not happening the way they used to. That's if they can happen. So I guess I just want to suggest that I agree with the technology group's report and the recommendations that were included. I also saw a memo from Kelly Myers, which I thought was excellent, and I would like that to be incorporated as well. And the memo from Kelly Myers, if you read it, indicates that, again, this is all assuming that the COVID task force, and I'm not sure I have the terminology for that position, but that person has put a plan in place that has been approved by the resident superior court judge. So I think with when we talk about a superior court judge and a clerk making sure that things can be done safely in conjunction with the COVID task force person, then we can start looking at, what trials are we going to have. And I believe that the suggestion that we start slow and graduate up to something that's lengthy is a good plan. Anyway, so I appreciate that. And those are my thoughts. One other suggestion is that we've talked about other states. I don't know if I want to compare with other states, given, like I said, since North Carolina's cases are going up on a daily basis. Other states, I don't know as well, but I don't believe that all of the other states have the prosecutors or the district attorneys having the calendaring authority. They may have other calendaring authority options with it being either with a clerk or a judge or some other entity. So I don't know that that's necessarily a good comparison. I think I just want to do what's good for North Carolina and for North Carolina citizens, for our judicial community. And I think we just need to wait a while, but I do like the proposal that's in the technology group report. Thank you.
Thank you, Ms. Harjo. Now, we have not heard from every single member of the task force but we have certainly heard from many members of the task force who have a direct interest in jury trials. Are there other members who wish to speak on this issue?
Your Honor, this is John McCabe on behalf of plaintiff civil lawyers and I guess to a degree criminal lawyers as well for NCAJ. Just one point of clarification. I've always been operating under the assumption that this group was not going to authorize a return of jury trials or recommend a return of jury trials unless they could be done safely. And in some of the communications that have been going back, there's at least a sense or an implication that civil lawyers are pushing to get back to doing jury trials. And I just want to clarify for the record that while we would like to get trials started, as I guess everybody would want to get trials started back, we certainly don't want that to be jeopardizing anybody's safety. We want safety to be the #1 priority. And I've always been thinking that that's the modus operandi for our group. Certainly the concerns raised by the clerk carry a lot of weight with us. But I just want to make it clear, we are not trying to push for the resumption of jury trials when the courthouses and safety are not ready for it. So thank you.
Thank you, Mr. McCabe. And to the extent that that impression may have been given, it may have come from the, at least in part from the language in my email in which I made reference to the fact that we've had expressions by the Conference of District Attorneys and from the Civil Bar of wanting to resume jury trials because of the importance of jury trials in getting cases moved. And I certainly did not intend for it to be that way. In fact, one of the points that we're trying to make clear in the draft of our plan for the resumption of jury trials is the point that jury trials only should be conducted so long as they are in complete compliance with the best safety practices that come out of our best safety practice work group. And I think I alluded to that previously, that Kelly's group not only has already provided us with a list of those practices for all in-person hearings, but we will yet receive an additional set of recommended best safety practices for application in the actual jury trials. And so one of the points that we also want to stress in the report that we submit to the Chief Justice is that no jury trials should be conducted at any point in time unless it can be done in safety and in conformance with those best safety practices.
Thank you, Your Honor.
Is there any other member of the task force that wishes to be heard on this issue?
Your Honor, J.D. Keister. I join in what Mr. McCabe said with regard to the civil bar, but would add that particularly swayed by the concerns that I've heard from the clerks and from the court managers. And I think the attempt that our subgroup made was to get some buy-in from that group. And so I think whether it be in the form of some additional extension or in having the clerks and managers having a direct voice, which I agree that they will have a voice in most counties, but I don't know that every county is as functional as the next or as team-centric as the next. That would be my only additional comment.
Thank you, sir. Any other member of the task force? All right. This is Don Bridges again. Let me try to summarize what I believe I have heard from this group. Now, let me preface my remarks by saying this. As I may have stated earlier, when we took our vote last week, we had a motion second, and then we engaged in discussion. One of the realizations I had at that time was that I had not fully understood the extent of concerns that wound up being expressed at that meeting last week. I may have been operating under some misconceptions as to the nature and extent of concerns or the lack thereof concerning jury trials. I have listened carefully to what you all have to say today, and I hear two significant points coming out of this discussion. One of those points, one of those recurring points that I'm hearing from a number of you is that the date of August 3rd may be too soon for the resumption of jury trials. The other point I'm hearing from many of you is that the work of the Technology and Innovations Work Group seems to be an appropriate framework that might be used in crafting our plan to be submitted to the Chief Justice. Now, in response to those comments, I would also like to make a couple of observations. One of those is that the Chief Justice has not specifically requested that we give her a recommended date for the resumption of jury trials. Ultimately, that decision will be made by the Chief Justice anyway. So it is entirely possible and feasible, and I think we will have carried out our mission if we craft a plan for the resumption of jury trials and leave the beginning date or the earliest possible date on which jury trials may commence to the Chief Justice, because ultimately she has that authority with or without our recommendation anyway. It's going to be up to her. So one possibility is that we simply craft our plan, submit it to her, that we stress the importance of waiting until those trials can be conducted with safety, and then we build into our plan all of the safeguards that we consider appropriate, all of the prerequisite steps that we consider appropriate in having local officials craft their own plans, and then whatever extent of details we also wish to include. But keep in mind that while many of us may feel that it's yet too early to start thinking about jury trials, it is not too early for us to finalize our plan for the resumption of jury trials. In fact, we've got to finalize our plan for the resumption of jury trials. We're operating under a June 30th deadline, and as Judge Corpening has reminded us time and time again, time is our enemy. We need to be moving on finalizing our plan. So for that reason, let me ask, how would you all feel about going forward with a plan that we submit to the Chief Justice and simply leave that date up to her? Omit that entirely from our plan for the resumption of jury trials so that she can give us that date sufficiently in advance to give the clerk sufficient lead time for the issuance of their summonses. Is that an appropriate step to take?
This is Billy West. I'd also request kind of along with that, since most of the target dates and the differentiating between cases were based on dates. I'd ask Mr. Evans as well, but I would think that my position and possibly his would at least be that just any reference to dates or types of cases should not be included if we're going to provide her. This is the recommendations from a safety perspective of what needs to be accomplished before they can resume. I don't know what the rest of the group, or particularly I want to know what Mr. Evans thinks about that.
This is Robert Evans. I agree with that. I just think that I just don't think it's tenable for us to get that far down into the weeds about deciding if we're going to concentrate on best practices for the safe resumption of jury trials. I don't know how that relates necessarily uniformly to what kind of cases are going to be tried. I do think it's a legitimate point that we need to be careful in our analysis in each district about the type of cases we pick, given that we're going to have varying degrees of resources. But I don't think our committee needs to get into that. So I agree with Billy.
This is Patrick Weed. I would respectfully disagree in part with Mr. West and Mr. Evans on that point. I think, first of all, that even if we take the date out, if we use the framework of what the Technology and Innovations Working Group has submitted, as well as a lot of the feedback, especially from the clerks today, that whatever we submit to the Chief Justice needs to include the concerns that have been raised, that August, for example, is not an appropriate date, such that the Chief Justice would understand that it appears the majority of our group feels that August is not an appropriate date, so that it, by accident, that date is not selected. I think that we also, even if we don't include a specific date, need to note that it appears to be the feeling of many on this group that serious trials, whether civil or serious felony criminal trials, be the last ones that are chosen or that are set for trial. That short trials would be both civil and criminal would be the best way to start. And I think that would go along with the health and safety issues as well, since 1-2 day trials, jurors are not going to be in a place for a long period of time.
Tom, this is Waylon Sermons. Having listened to all this, I'm still of the opinion that one size doesn't fit all. And having a date that jury trials may start after is merely that. I don't believe anybody in this whole state is going to be able to try a case in a jury without having consulted with every player on the team. And put a date, don't put a date. But, I'm moving forward with attempting to try something on August 10th in one of my counties. And we're trying to figure it all out. We're working towards it so we make the end of June deadline for a possible, early July for a possible jury venire summons. I don't know how it's going to work, and if it doesn't work out between now and the time we spend the summons, then we won't do it. But we need to have the flexibility to do what we want to do. And Billy, I understand your situation. I understand the DA's situations in some counties. I don't think many of us have a situation where the DA can't talk to the Superior Court judge and say, we don't really think we can do that now, but we can do it later, but let's do this. And if you're in that situation, then I don't think anything we do is going to make any difference. So I think leave the dates where they are or take them out. Irregardless, we've got to have local cooperation. And, while we're talking about all this, the rest of the time I'm spending my time doing it and arranging it and getting it set up. And so what I'm going to do is probably going to bypass whatever the chief recommends because I can do it safely. And so I just think that we need to move on forward with getting it done rather than figuring out who's going to call the shot on what kind of trial or whatever. It's got to be all agreed upon anyway. So that'd be my comment.
Judge Bridges, this is Kelly Myers, and I would ask just if we could step back a moment, if it's okay, and I don't mean to overstep you, but if we could decide, I think it'd be a little easier if we could agree as a task force, if we are going to include recommendations for jury trials, however they look, in this document or in a second follow-up document. I don't know if we've even agreed on that yet. And that if we're going to include them in this document, then we have a lot more work to do before June 15. If we're not going to include them in this document, then I think we do have some time, not a lot, but we have until June 30. And so I would just ask if we could maybe get an agreement on that piece first.
And I apologize, Kelly. I was under the impression that it sounded like we had a consensus to proceed with this report without the plan for jury trials. But
Okay,
why
great.
don't we entertain a formal motion to that effect if there is one? Is there a motion that we omit any plan for jury trials in the first interim report that's going to be submitted by June 15th?
I'll make that motion. Kelly Myers.
Teresa Vincent, I second that motion.
All right, we have a motion and second. Is there any further discussion of that motion? Can we call for a roll call vote on that point?
Judge Bridges,
I vote yes.
Judge Corpening,
Yes.
Judge Sermons,
Yes.
Judge Vincent,
Yes.
District Attorney West,
Yes.
District Attorney Evans,
Yes.
Clerk Johnson,
Yes.
Clerk Shingary,
Yes.
Kinsley Craig,
Yes.
Kelly Myers,
Yes.
Mr. Cheek,
Yes.
Ms. Harjo,
Yes.
Mr. McCabe,
Yes.
Mr. Harrison,
Yes.
Mr. Weed,
Yes.
and Mr. Keister.
Yes.
That's everyone.
All right, that appears to be a unanimous agreement on that point. Next point, could we decide whether or not we can omit a recommended date for the resumption of jury trials in our reported plan to the Chief Justice concerning the resumption of jury trials? Is there a motion to that effect, that we submit a plan for resumption of jury trials, but leave the date to the Chief Justice for her determination based upon when she is satisfied that it would be safe to do so?
Can we have a little discussion first?
Yes, sir.
What does that do to the people that have already moved this ball further down the road to be doing something like August 10th? Suppose she says, oh, no, now I think we ought to go to August 30th or September 1 or whatever the date is. I mean, it seems like to me she's had this out here since when, the 21st of May? And a lot of us have relied on it. So that would be my thought. Leave it alone.
Judge Sermons, do you, now I'm not making the motion, I'm simply calling for a motion. Do you have a motion you would make in that regard?
Yeah. Well, I don't think a motion's required to do nothing. I say we leave it like it is. I mean, we recommend, that she follow the date she's already selected. Would be my opinion. And, if she wants to try to change that, that's fine. I mean, these are recommendations to her, and she writes the orders.
Danielle, I know I'm not a task force member, but I'm not sure if she's put anything out with a specific date. She just said no jury trials before the end of July at the earliest. And I think the notion was always that she was going to come back and revisit that, but Anna might be able to clarify that if she's not on anymore.
Well, okay.
Judge Bridges, it's Kelly Myers again. I agree with Judge Sermons in that I'm wondering if we should focus our efforts on how to safely resume jury trials, and then if we can do that and get it approved by the full task force before June 30, then maybe revisit if we want to include a date or not. But maybe let's focus on the meat of what those safety recommendations are going to look like that we want to put out there.
Judge Bridges, Teresa, does I concur with Ms. Myers.
All right. Is there any further discussion on that proposal? That we focus on our framework, and if I understand correctly, Ms. Myers, you're saying simply leave the dates to the chief
Yes, sir.
and focus our efforts on the safety surrounding the resumption.
Yes, sir.
All right. Well, here's what I propose. The work group from the Superior Court judges has done a lot of the work on the currently existing draft of the plan for resumption. I would propose that we reconvene a meeting of that work group during the next week to further refine the draft of the plan, that the plan will specifically make reference to and incorporate all of the best safety practices that come from the best safety practices work group, both for in-person hearings and for jury trials. That the Superior Court work group also will seek to incorporate the work of the Technology and Innovations work group into the existing draft. And we'll come back to this group at our next meeting with a further revision of the plan for resumption of jury trials. Oh, and the other thing I meant to mention, that meanwhile, I would like to request that the Conference of Chief District Court Judges also provide to our work group any further consideration. Now, the expression I heard from Judge Vincent was a request that the Chief District Court Judge be included as part of that local COVID work group in making those decisions about local plans. That may or may not be the only request from the district court judges. So to the extent that there are additional requests from the district court judges, I would ask that your conference meet and forward to us any additional requests or suggestions that you all would like to have incorporated into the plan. We will go back and try and make further revisions based upon the new recommendations of the Technology and Innovations work group. Now, I don't know that that gives us anything to vote on at this point, but it sounds like that might give us something as a more workable arrangement. Any further comments on that proposition? Let me ask one other question, and I meant to do this earlier, frankly, and I just failed to do it. And Ms. Harjo, I'm not trying to put you on the spot, and if this is something that you may need to think about for a while and then provide later input in through another communication, I'll be happy to let it be handled that way. But with regard to your position concerning no trial taking place without consent of the defendant, at least for some period of time, would it to any extent satisfy your concern in that area if our plan included a provision that those ultimate decisions that are made by the trial judge that have been reflected in from a couple of different work group submissions, if we include a specific provision that in that ultimate decision the judge shall take into account and give consideration to consent by the defendant to go forward with the trial or the lack thereof?
Okay, as I understand your question, I think that would be helpful, and I think that would be comforting, I guess, to clients and to lawyers on behalf of their clients to know that whatever protections are taking place to accommodate a jury trial are accommodations that are made with the consent of the defendant, because you know a trial has, yeah. So I mean, it just in the course of trying to cross-examine witnesses and present evidence, I'm concerned that the accommodations are going to interfere with the lawyer's ability to do that on behalf of the client. So if the lawyer and the client, or the client actually, is comfortable with whatever accommodations are taking place, I think that's important.
I wanted to throw that out for your consideration and see if that would give you a little more comfort if our proposal had that sort of language.
Absolutely. Yes. Yes, sir.
All right. Judge Corpening, with that, I believe that will end this discussion. I'll turn the floor back over to you for whatever action you deem appropriate with regard to what we've done on this topic.
All right, we seem to have reached, this is Jay Corpening, we seem to have reached some consensus about getting additional information from the senior residents who have been meeting, and I may have misspoken whether it's senior residents or Superior Court judges, but the work group that Judge Bridges referenced, plus Kelly Myers' group, is continuing to work on best safety practices connected to jury trials and resumption of jury trials. And so it's important, I think, to have that information before we move. And we've also agreed to take this piece of the interim report out of the one that we're going to try to submit to the Chief Justice right away. So, and Judge Bridges, there was no other motion that was made related to any of that, but there certainly seemed to be consensus about gathering that additional information and circling back at our next meeting. Yes, my question at this point would be for Kelly Myers. Do you have any sense of whether by late next week your group would be able to make a recommendation, or do we need to be looking into the next week?
My hope is to have at least a draft recommendation if we meet again at the same time later next week. It may not be a pretty draft, but to have at least a draft in language so that the larger task force can start working through that. So yes, sir.
Right. Thank you. Judge Bridges, does that meet your timeline?
Yes, sir. I think so.
Right. Any dissension from the group or any other suggestions from the group about handling it any differently than to gather that additional information by next week? All right, then, Judge Bridges, I've got a meeting of, it's not a called meeting, but we can make it a called meeting of the Chief District Court judges on the 11th at 1 o'clock. If we could convene this meeting at 2:30, that will have given that group a chance to discuss the issue as you've requested. And then I'll be in a position to provide input about that.
Thank you, sir.
And Kelly, does Thursday of next week, Thursday afternoon, is that late enough in the week for your group, you think?
Yes, sir.
Right.
We'll certainly try to get it out sooner, of course, if possible.
Right. Then, and obviously we'll welcome continued input from any of the interested folks. Certainly, Conference of DAs, you have been working hard on this issue. So any other input will be welcome. So Judge Bridges, we have an item on any suggested statutory rule changes or additional funding concerns. Anything on that today?
Yes, sir. I'll be very brief on this. This is an item that I believe can wait until our next report past this first one. I would make a couple of requests to the various work groups. First of all, now that you've completed your first round of work, I would request that you go back and scrutinize your work with a view toward, is there anything that we have already recommended or that we are considering for our intermediate or even long-term recommendations that may require statutory amendments or rule changes? In other words, action by the General Assembly or by the Supreme Court in changing the framework in which we operate. If so, it would be very helpful to receive a list of those proposed changes so that we can include them in a separate section within our report and have those all in one place, all in one location. So I would make that request of each respective work group. Secondly, as to monetary considerations, I would also make a request of each individual work group, to the extent that you feasibly can do it. It would be helpful if we can get at least some idea, and you may need coordination with the administrative office of the courts in this regard to get some idea of what, if any, additional costs might be involved in any recommendations that you're making, so that we can pass that along in the form of requests for additional resources. So that's the extent of what I wanted to touch on under that category.
Thank you, Judge Bridges. This is Jay Corpening, and I'll offer one follow-up on that. Even if you're not able to identify a specific dollar amount, if there are, for example, if you believe that as part of your recommendations that we'll need additional laptops, then that needs to be addressed. If you believe we'll need flat panel monitors in courtrooms, but don't have a dollar figure, then I think that needs to be addressed. So even if you can't come up with a dollar number, then any equipment needs, anything that we would need to spend money on, at least needs to be addressed by category. But certainly if you can get an estimate of what it would cost, then that would be helpful. Judge Bridges, is that a fair addition?
Yes, sir. Absolutely.
All right, then. Thank you, Judge Bridges. So we'll move to Roman numeral number 4, approval of draft report to the Chief Justice. And let me introduce that by saying that Danielle Carmen has been tireless in her drafting efforts, so tireless that she's exhausted. Thank you, Danielle, for all of your work on this. And based on our conversations today and the vote that has been taken, we would be removing anything related to the resumption of jury trials from this interim report going to the Chief Justice. So, for example, Emily, if you can put up the table of contents for the report, then we would need to take out recommendations on the resumption of jury trials, and then also Appendix E, stakeholder comments about jury trials. And I think that would then set us in motion to have an additional report in a couple of weeks that will meet the Chief Justice's deadline. So,
Your Honor?
Yes.
This is Danielle. I just wanted to clarify also that I assume I'm going to be removing this. I'm pointing on my screen. You can't see where my mouse is. That I'm also going to be removing the section on page 8. On page 7. No, page 8 about suggested statutory rule changes. And then I did have a question for the task force about whether you all intend or want but for the jury trial issue, the tech and innovations intermediate recommendations, again, not including the jury trial issue, whether you want that reflected in this report.
I'm open. Some of our conversations have been about making this report immediate recommendations, and then perhaps submitting intermediate with the report by June 30th. Judge Bridges, your thoughts?
Judge Corpening, I would defer to Judge Henry on that. It's his work group, and if this is a final report, even though it's more than immediate recommendations, we could include it in this report. But what is the preference of that work group?
What's your deadline?
June 15th.
I intended the long-term recommendations was I was going to meet with them Monday or Tuesday based upon the availability of the members.
No, I'm talking about what you submitted today, Judge Henry. I'm not talking about what you have yet to submit.
Okay.
Would you like to have the report that your group did this week included in the interim report that's being provided right away to the Chief Justice? Or would you like for that to come in the next report?
Probably I don't know, sooner the better. So let me, I will conduct a poll with the members and see, and let you know by the first thing tomorrow morning.
So this is Jay Corpening. The suggestion that I would have, Judge Bridges, is that we look to include the report we got from Judge Henry's work group in our report that we will send to the Chief Justice about resumption of jury trials.
Okay.
And not this immediate report that I'm hoping we're getting ready to vote on. I'm hoping. So that we can send this piece off to the Chief Justice consistent with our conversations, and then followed within just less than, well, about 10 days, our next report relating to jury, resumption of jury trials, but also include Judge Henry's work group's recommendations on innovation and technology. And there may be additional recommendations at that point from Kelly Meyer's committee as well.
I agree with that.
Right. So then, Danielle, I think that takes that intermediate report out until the next report in response to your question. So we had a few comments that came in about the draft report. Several of those comments were made. Kelly Myers, you had a couple of things that you had sent in advance of the deadline. One of those seems to relate to jury trial resumption specifically, but do you want to address either of those things right now?
No, sir. They can wait.
All right, thank you. One of Kelly's comments was about requests for excusals and continuances, and then the other that a safety plan be submitted, so we can do that as part of the resumption of jury trials. Thank you, Kelly.
Yes, sir.
All right, then, with the deletion of the recommendations relating to jury trials, with the removal of the intermediate recommendations from the Technology Innovation Committee, I'll say that one of the comments that's on this page that you can see right now is that I had asked that some of the parts of the appendix for the juvenile work group be included and that hyperlinks be included. We were already including comments from each of the stakeholder groups on case priorities, and some of the parts of the appendix included some model forms and some other issues that I thought needed to be in the appendix. So at this point, any discussion about the draft report as we have just described it being constituted? Hearing none, is someone willing to make a motion to approve that report and send it to the Chief Justice?
Teresa Vincent, I make a motion that we approve the report and submit it to the Chief Justice.
All right. Motion's been made by Judge Vincent. Is there a second?
This is John McCabe, second.
Thank you. Motion's been made and seconded. Any discussion? Hearing none, roll call vote, please. Emily?
Judge Bridges,
I vote in favor, yes.
Judge Corpening,
Yes.
Judge Thurman,
Yes.
Judge Vincent,
Yes.
District Attorney West,
Yes.
District Attorney Evans,
Yes.
Clerk Johnson,
Yes.
Clerk Shingari,
Yes.
Kinsley Craig,
Yes.
Kelly Myers,
Yes.
Mr. Cheek,
Yes.
Ms. Harjo,
Yes.
Mr. McCabe,
Yes.
Mr. Harrison, Mr. Weed,
Yes.
Mr. Keister,
Yes.
All right, thank you. Motion carries. We will delete the items that have been referenced and put it together in the package and send it to the Chief Justice. Thank you for all your work on that. All right, goals for next meeting. I suggest at this point that our goal be to have further input from each of the stakeholder groups addressed by Judge Bridges on the resumption of jury trial issues so that we can have another discussion about that. Certainly all of those are important issues. And I think that's probably the priority for our next meeting. Judge Bridges, other goals that you would ask us to add for next week?
It would be nice to at least begin discussions of those other topics that we talked about, statutory or rule changes and funding requests.
Yes.
At least begin some discussions of those.
Absolutely. Any other goals for our next meeting that members of the task force would suggest? All right, then we will meet next Thursday, June 11th, 2:30 p.m. I want to thank all of you for your diligent work and for your participation today. Your opinions are all valued. Absolutely. So with that, we'll adjourn this meeting and reconvene next Thursday, the 11th at 2:30 p.m. Thank you, everyone.
Thank you.
Appreciate it. Have a good weekend.